Court has heard oral arguments in Case versus Montana. It's a case tied to the Fourth Amendment.
Unanimously upholds a Montana Supreme Court decision allowing law enforcement to enter a home without a search warrant.
Some sort of emergency is afoot before they can enter into somebody's house without a warrant. Where the outcome is, it's going to set a constitutional standard for police behavior throughout the entire United States.
The controversy has erupted where they're going to be apprehended and they run behind a closed door and lock the door.
Able to look through the window and see him with a gun pointed to his head, or they need to see a dead body on the floor? What more did they need?
Officers respond to these sometimes very tricky situations that they simply have to act reasonably.
The Supreme Court just handed down a unanimous 9-0 decision in Caniglia versus Montana, and it fundamentally changes when police can walk into your home without a warrant. All 9 justices agreed. This is not a split decision. This is not a close call. The court created a brand new standard for warrantless home entries under the emergency aid exception to the Fourth Amendment. And if you own firearms, you need to understand exactly what this means for you. I'm going to break it down piece by piece right now. Here's why this should matter to you personally. If you keep firearms in your home, and most of you watching this do, this ruling just made it easier for police to get through your front door without a warrant, not because they suspect you of a crime. Not because a judge signed off on anything, because a neighbor called 911 and said they heard something concerning. Once officers are lawfully inside under this new standard, every firearm they see in plain view, your rifles against the wall, your handgun on the nightstand, all of it gets documented. And in states with red flag laws, that documentation becomes the foundation for an extreme risk protection order. Your guns get confiscated, and you're fighting to get them back in court after the fact. That's not hypothetical. That's exactly what happened to the defendant in this case. So stick with me here because the details matter. Alright, so let me walk you through what actually happened in Caniglia versus Montana. Neighbors called 911 reporting loud crashing sounds and yelling coming from the residence. They told dispatch they were concerned someone inside might be hurt. Officers arrived, knocked repeatedly, got no answer. They could hear sounds inside, described in court documents as moaning or distressed sounds. They announced themselves as police responding to an emergency. Still no answer.
Set to hear oral arguments in a case that could impact what's needed for law enforcement to enter your home without a search warrant.
Court has heard oral arguments in Case versus Montana. It's a case tied to the Fourth Amendment.
What's it take for an officer to determine there's an emergency and then enter into your home without a search warrant?
Unanimously upholds a Montana Supreme Court decision allowing law enforcement to enter a home without a search warrant.
They tried the door, found it unlocked, and entered without a warrant under what's called the emergency aid exception. That's the legal doctrine that says police can enter your home without a warrant if they reasonably believe someone inside needs immediate help. What they found was the resident Caniglia lying on the floor. He was conscious but injured from a fall. He was intoxicated but not seriously hurt. Here's the critical part. Officers also observed firearms throughout the home in plain view. Rifles leaning against walls, handguns sitting on tables. They called medical services and after evaluation determined Caniglia was intoxicated but not in serious medical danger. No arrest was made that night. But officers filed a report documenting every firearm they observed. They noted concerns about Caniglia's ability to safely possess firearms given his intoxication and injuries. Based on that report, Montana authorities initiated red flag proceedings under the state's Extreme Risk Protection Order statute, and Caniglia's firearms were temporarily confiscated. He challenged the entire thing. He argued the warrantless entry violated the Fourth Amendment, that officers lacked sufficient justification under the emergency aid exception. He also argued that everything they observed inside, including every firearm, should be suppressed. The case went all the way up. The Supreme Court took it to resolve a circuit split, meaning different federal courts around the country were applying different standards for when police could invoke this exception. Some circuits required full probable cause. The traditional standard, meaning officers needed to show it was more likely than not that an emergency existed. Other circuits allowed entry based on reasonable suspicion, the lower standard used for Terry stops. That comes from Terry versus Ohio, the 1968 case that lets officers briefly detain someone based on articulable suspicion of criminal activity. The court rejected both extremes. On January 14, 2026, Justice Elena Kagan delivered the unanimous opinion establishing what the court called an objectively reasonable basis standard. Let me translate that. Police don't need probable cause, which is more than a 50% likelihood, but they need more than reasonable suspicion, which is basically a hunch supported by a few facts. The court created a middle ground. Officers need an objectively reasonable basis for believing that someone inside is seriously injured or faces imminent threat of serious injury. And here's the key word: objectively.
Some sort of emergency is afoot before they can enter into somebody's house without a warrant.
An officer shot Case after he threw open a closet curtain while holding an object that looked like a gun.
The outcome is it's going to set a constitutional standard for police behavior throughout the entire United States.
Officers respond to these sometimes very tricky situations that they simply have to act reasonably.
The officer's subjective good faith is not enough. It doesn't matter if the officer genuinely believed someone was dying inside. What matters is whether a reasonable officer looking at the same facts would have reached that conclusion. The court laid out specific factors: the nature and source of the information, whether it's a 911 call from a known neighbor versus an anonymous tip, the officer's own observations at the scene, sounds, smells, visible conditions, the time-sensitive nature of the situation, attempts to make contact with occupants, and whether reasonable alternatives existed before forcing entry. Now, let me put this in context because this didn't happen in a vacuum. Back in 2021, the Supreme Court decided Caniglia versus Strom, a different Caniglia case out of Rhode Island. They unanimously held that the community caretaking exception, a doctrine that previously applied to vehicle stops under Katie versus Dombrowski from 1973, does not extend to the home. That was a win for Fourth Amendment rights. The court said police can't just show up at your house and claim general caretaking authority to justify a warrantless entry. But Caniglia versus Montana carves out something different. The emergency aid exception is narrower than community caretaking, but after this ruling, it has teeth, and here's what's really important. This decision interacts directly with red flag laws. Right now, 21 states and the District of Columbia have some form of extreme risk protection order statute on the books. In most of those states, law enforcement observations during lawful entries can be cited in ERPO petitions, so you've got a pipeline. Concerned neighbor makes a call, police show up. They enter under the emergency aid exception. Using this new objectively reasonable basis standard, they see your firearms in plain view. They file a report. That report becomes Exhibit A in a red flag petition. And suddenly you're in court fighting to get your own property back, property you had every legal right to own. This also connects to what we're watching in the courts with cases like United States versus Rahimi decided in 2024. The Supreme Court upheld firearms restrictions for individuals subject to domestic violence restraining orders under an 8-1 decision. The trend line here is clear. The court is willing to uphold mechanisms that remove firearms from individuals when the government can show a safety justification. And Caniglia versus Montana just made the front end of that pipeline, the initial home entry, easier to justify.
Ransack your house, arrest or detain you without any judicial warrant. That's a violation of the Fourth Amendment.
And that is a sufficient legal authority to go and apprehend someone. They have violated the law.
This ruling will allow officers to continue to keep their communities and citizens safe to the best of their abilities.
3 Elyria police officers storming into a man's home and arresting him. They did not, we found, have a warrant.
So let me give you the honest assessment. Is this ruling a disaster for gun owners? Not entirely. The court did several things that protect you. They required the standard to be objective, not subjective. That means officers can't manufacture justifications after the fact. They limited the exception to serious injury or imminent threat of serious injury. Vague concerns about someone's well-being aren't enough. Minor injuries don't justify entry. General welfare checks without specific facts indicating serious harm don't meet this threshold. And all 9 justices agreed on that, including justices who are typically skeptical of expanding police powers. Sotomayor and Gorsuch both signed on. That unanimity matters. It means this standard has broad constitutional legitimacy and is unlikely to be revisited anytime soon.
The controversy has erupted where they're going to be apprehended and they run behind a closed door and lock the door.
Able to look through the window and see him with a gun pointed to his head, or they need to see a dead body on the floor? What more did they need?
We want to add an entirely new layer of warrant requirement. Okay, they want to have a judicial warrant.
But let me be clear about the risk. This is a lower standard than probable cause for entering your home, the most constitutionally protected space you have. And the plain view doctrine means that once police are lawfully inside, anything they can see is fair game for documentation. They can't open your safe, they can't search your drawers, they can't rummage through closets. But if your firearms are visible, they're going in the report. So here's what you need to do right now. If police show up at your door claiming a wellness check or responding to a neighbor's call, answer the door. I know that sounds counterintuitive, but refusing to answer gives officers additional facts supporting their belief that someone inside might be hurt. Answer promptly. Step outside. Close the door behind you. Demonstrate that you're fine, that you're coherent, physically healthy, and not in distress. That can eliminate the objectively reasonable basis right there. Do not invite officers inside. Do not say sure. Come in and take a look. The moment you consent, the emergency aid exception becomes irrelevant because you just waived your Fourth Amendment protection voluntarily. If officers state they're entering under the emergency aid exception despite your refusal, do not physically resist. State clearly, I do not consent to this entry. Step aside, document everything. Record, if it's legal in your state, and do not answer any questions about your firearms without an attorney present. How many guns do you have? Are those yours? Where do you keep your ammunition? None of that. Fifth Amendment, get a firearms attorney on the phone immediately. Here's where things stand right now. Caniglia versus Montana is the law of the land as of January 14th, 2026. The objectively reasonable basis standard applies nationwide. If you live in a red flag state, the connection between emergency aid entries and extreme risk protection orders is real and it is active. Store your firearms out of plain view. That's not legal advice, that's common sense. If police lawfully enter your home and there's nothing visible, there's nothing to document. Keep watching this channel because emergency aid exception cases are developing fast. The intersection with red flag laws is only going to get more significant. I'm tracking every case, every ruling, every legislative development that affects your Fourth Amendment and Second Amendment rights. That's it for today, folks. See you in the next video.